do you keep the generational family property in the family? Hi, I'm Alec Osland, an attorney at Yanowitz Law Firm, where we've been assisting families with wills, trusts, and probate for over 30 years. Whether it be a family farm, family business, or family cabin, these are all assets that have a large amount of sentimental value. Nobody ever gets attached to a 401k. And so that's why with the estate administration, we generally don't see people arguing over what happens with mom or dad's retirement plan. But where we do see fights is what's happening with the cabin. Everyone has all these memories there, whether it's the family business and how's this going to operate now, or that family farm, and thinking, who's entitled to what. These are all assets that we see a large amount of issues with when mom and dad pass away, and we start saying, okay, what's the next steps with these family assets, and are they going to stay in the family? While mom and dad are alive, they're the boss, which is why we generally don't see disputes over how these family assets are managed. When mom and dad are alive, they get to pick and choose, what happens with these assets, whether it be who uses the cabin over the 4th of July, whether the farm's going to buy a new combine, or whether we're going to buy certain equipment for the business. They are the decision makers, and what they say goes. When we see issues, it's generally when the next generation comes into ownership, or even the generation after that. We may have a bunch of different people who now don't agree and don't get along with the management of this family asset and what the best steps are going forward. When we start looking at the next generation, one of the biggest issues with these assets, and it comes down to money. There's always the issue of, who's going to pay for this? Is it needed? When we look at something like property taxes, hey, we got to pay property taxes, and everyone generally understands that. But if it's something like, looking at the family cabin, you may have one child who wants to upgrade the kitchen while the other children don't. What happens if the roof needs to be repaired? Are we expecting the children to, all pay for that, or have one pay it and then the others reimburse them? It could cause some tension between the family, which is not what we want. Another thing to think about is ownership. When your children now take ownership of this property, what happens with that ownership? Are they allowed to add a spouse on? Can a spouse be a co-owner? What happens if they want to transfer that property? And now there's this random third party who nobody knows about, and they're a co-owner of the business or the cabin or the farm. Generally, that's not what we want, is we like to keep things, in the family, down through the bloodline, so that the future generations can also enjoy these assets just as we have during our lifetime. Another thing to think about is if you have a child who maybe they stayed home, they helped with the family business, they helped on the family farm. Whereas the other children, maybe they went to university or trade school, they moved across the country, and the family business or family farm, it wouldn't be what it is today without their help. On the cabin, maybe you have a child who's put a bunch of time and sweat equity at refurbishing the cabin and making it is what it is today. Without them, that cabin would be worth significantly less. And so how do we treat those children compared to their siblings? As fair does not always mean that everything is going to be distributed equally. These are all things that you have to think about when you have these family assets and you want to keep them in the family. Now, there's 3 different ways that we can look at transferring these assets. The first is as tenants in common. This is a very simple approach, and it essentially just conveys out the asset equally to the number of children that you have. So if you have 3 children, you're just conveying the asset 1/3 to each child. There's no restrictions on that transfer. It's theirs. They get to do with it what they want. While it is simple, it provides no limitations for, again, how that property can be transferred. And also, it provides no liability protection as well. When we see the assets being transferred outright, that's when we get into a lot of issues with, okay, now we have this third party because a child sold their share, and it can just cause a lot of headache for everyone else in the family. What do we generally recommend? Another option instead of the tenants in common could be to create an entity such as maybe a partnership or an LLC. A benefit of creating an entity like this is it does create some liability protection, and it's something that you can create now. Now, when I talk about partnerships and LLCs, these can be used for businesses, farms, and cabins. With these entities, you also want to have a buy-sell agreement that's going to govern how the entity can be transferred, which is something we're going to talk about more later on with the buy-sell agreements. You can also have managing and non-managing members of these entities, and you can put seed money in the entity to help pay for some of those expenses that we talked about earlier. A negative of these entities is while it does offer some liability protection, it doesn't offer the same as trust, and it is easier for a child to maybe force the entity or the other partners or members to purchase their interest if they do want out. These entities are going to have business documents that govern how the entity operates and transfers with the shares of the entity itself. We can set up these documents to lay out the management structure and also set it up in a way to have voting and non-voting interest, which allow us to still pass along some economical benefit to the next generation, but yet still retain full control. And what I mean by that is we can set up the structure now to have, mom and dad having management voting rights, but the children have no voting rights, but yet the children can still benefit economically by having some shares of the company, but not being in control. Now, regarding those buy-sell agreements that I talked about earlier, this is a very important document that is necessary for all multi-member entities. This agreement is going to control what happens for future transfers or sales. It's going to talk about what are the triggering events, if there's certain time restraints, what's the price of each share, are we giving a discount, how is that discount determined, is it the fair market value, is it appraised. It's also going to talk about if a child or an owner can pass their share to a spouse. Are they allowed to pass it to a lineal descendant? And it's also going to talk about, rights of first refusal. Do the surviving members or partners, do they have an option prior to a spouse or a descendant taking that ownership? Do they have an option to purchase those shares? And what does that purchase price and close of that transfer look like? Overall, these buy-sell agreements are going to detail what happens when a member passes away or wants out and how their shares are valued. It's also going to talk about what happens if a member becomes incapacitated. Are they required to sell? What happens if a member or partner goes bankrupt? We can protect that from creditors. An important clause is what happens if that member or partner gets a divorce? How do we protect the family asset from the divorce to make sure that that ex-spouse isn't involved with this family asset? So these are all very important things to think about when we start looking at that buy-sell, and we want to make sure all of those provisions are in the document itself. With trusts, we do have a greater liability protection than the entities if those trusts are set up for someone else other than the creator of the trust. And the nice thing is, very similar to the entity, we can still restrict how that property is going to pass. We can also have seed money that helps pay for the large expenses that comes with the types of assets that we are discussing. Overall, the entity approach and the trust approach are very similar to each other because we can restrict the passing of the shares ownership structure however we want. It's very important that we think about what are all the ins and outs here of the family asset and what are our goals with this, and that's going to outline whether we want to set up an entity, whether it makes sense to have this asset in trust, or if we really don't care and just want it to be simple, okay, maybe we just have it go to tenants in common and it's our kids' issue. All of this is important when we're thinking about what are the future goals for this family property. Do we want to make sure we're restricting this and trying to keep it in the family for as long as possible? All of this is very complicated, which is why it's very important that you work with a law firm that has experience drafting documents to keep these family assets in the family. Again, I'd like to thank you for joining me today, and I hope you learned something about keeping generational assets in the family. Make sure you subscribe to our YouTube channel to find out when we post more videos. Thanks, and have a great day. Bye.